Assalamu alaikum, welcome back to our channel, AI Era Islamic Abrahamic Wisdom. We're embarking today on a deep dive into what many legal historians, what they consider the single most critical administrative and legal document in the formative years of Islamic civilization.
And specifically, today we discuss Mr. Zahir Ahmad Mir's extraordinary work, The Foundation of Islamic Jurisprudence. We're focusing heavily on Volume 1, Sub-Volume 3, which covers the constitutional decisions of Hazrat Umar ibn al-Khattab. May God be pleased with him.
And our source material is laser-focused, right?
It is. It's exclusively centered on Case 10. The Judicial Letter sent to Governor and Judge Abu Musa al-Ash'ari, drafted around 15 to 16 AH.
So that's roughly 636 to 637 C.
Correct.
And this isn't just, a simple historical text. The source describes it as a fundamental restructuring of how justice was even dispensed. Our mission today is to unpack why this letter is consistently hailed as the first written code of judicial procedure and a binding judicial constitution.
Exactly. It set precedents that, frankly, predate so much of what we consider modern legal process. It codified universal principles of justice.
It's really foundational stuff.
It is. And before we fully unpack the text, I'd just like to ask our listeners, if you find this deep dive valuable, please subscribe to our channel, like this video, and share this information with your friends.
Absolutely. We believe this knowledge deserves a really wide audience.
It does.
Okay, so let's unpack the context first. Because, understanding the world Hazrat Umar was governing, it just makes the solution he developed all the more remarkable.
Right. The sources describe a state in a period of unprecedented, almost violent, and incredibly rapid expansion.
We're not talking about slow organic growth here.
Not at all. We're talking about the immediate aftermath of the initial conquests, territories stretching across Iraq, Syria, Egypt. I mean, these are diverse lands with ancient, entrenched, and often conflicting legal and cultural traditions.
And they were all suddenly incorporated into this new state.
Exactly. And to manage these new territories, new judges, qadis, were being appointed over these massive, multi-ethnic, multi-religious populations.
The constitutional problem there is just enormous, isn't it?
It's staggering.
It's the potential for the systemic fragmentation of justice. If you have Judge A in Basra using entirely local customs.
And Judge B down in Fustat in Egypt, relying purely on his personal insight.
And maybe Judge C in Damascus is just sticking rigidly to textual commands without any procedure. You don't have a legal system.
You don't. You have a collection of individual verdicts, a lottery.
And that lack of uniformity, that's what threatens the legitimacy of the entire state, right?
That's the perfect way to put it. Hazrat Umar was keenly aware that this inconsistency would inevitably lead to an utter loss of public confidence in the judicial system as a whole.
Which would then undermine the moral authority of the caliphate itself.
Yes, the whole project.
And the sources, they detail 4 specific, really tangible risks he was trying to eliminate with this written code. Can we break those down, maybe focus on how they would have affected an average person on the ground?
Certainly. The first risk was simply the sheer chaos of different rules in different regions. Imagine a major property dispute.
Okay.
If the outcome depends entirely on whether the case is filed in Kufa or Mosul, the very idea of property rights collapses.
Right. A citizen has to be able to expect a stable, predictable ruling, no matter where they are within the state.
It's the foundation of a functional economy and society.
And the second risk?
The second was the threat of arbitrary emotional decision-making. Look, we've all encountered people having a bad day.
Of course.
In a judicial system that relies only on the personal piety and wisdom of the judge, what happens when that judge is exhausted, or going through a personal crisis, or just misjudges the atmosphere in the room?
Justice becomes a lottery. It's dictated by the judge's mood.
Exactly. Which leads naturally to the third major risk, influenced by power or status. In a vast, growing empire, the elites.
The powerful merchants, the local governors, the military commanders.
They will inevitably try to sway judicial decisions. Umar needed procedures so robust, so transparent, that they could resist that political pressure.
He had to make it difficult for the powerful to get special treatment.
Difficult, if not impossible.
And if those 3 things, inconsistency, arbitrariness, and bias, if they take root, you end up with that ultimate failure, the 4th one.
The loss of public confidence. If people believe the courts are corrupt or slow or they just favor the powerful, they stop using them.
And they resort to what? Violence? Tribal vendettas?
Private settlements, vendettas, social collapse. It's the end of the rule of law.
So this whole deep dive, it really begins with this recognition that judicial independence by itself isn't enough.
It's insufficient. Giving a judge freedom is meaningless if they aren't bound by a structure. Umar mandated that justice must be predictable, fair, and above all, consistent.
It had to transcend the personality or the individual wisdom of Abu Musa al-Ash'ari or any other judge.
It had to be bigger than any one person.
And that transition, that's where the constitutional breakthrough lies. It's the moment where judicial ethics, high moral expectations, are formalized. They're transformed into written procedural law.
Yes. Before this letter, you relied on the judge's good character. After this letter, you relied on the binding external system.
So the sources, they highlight several specific constitutional breakthroughs here.
They do. First, and this seems simple, but it's huge.
Yeah.
The law was codified. It was written, not secret. That means litigants could know the standard they were being judged against.
That's transparency.
It is. And second, judges were now bound by procedure. They couldn't just invent rules on the fly. It created external accountability.
And this shifts justice from being a kind of personal gift, something bestowed by a wise man, to being an institutional right.
A predictable output of a rational, formalized state function, not a favor.
Exactly. This institutionalization is so essential.
And finally, the letter cemented equality before law through the very structure of the court process itself, which I think is where we should start.
Let's do it. Let's move into part I and look at these immediate instructions for fairness and due process, beginning with the environment of the court itself. The very first instruction tackles that human element head on.
Yes. Equality before the court. The mandate is, it's powerful in its simplicity and its scope.
What's the exact wording?
Let people be equal in your court, in your gaze, in your seating, and in your judgment.
Wow. So this is not just an abstract ethical instruction. It's a directive for courtroom management, for behavior.
It is. It's intensely practical.
Here's where we get into that practical application. Why is the mandate so specific about the judge's gaze and the seating? It's almost like stage direction for the judge.
Because it's about the visual, the palpable demonstration of neutrality. Imagine a scenario. A powerful merchant whose trade provides tax revenue to the state, and a humble farmer. They're in a dispute over a boundary line. If the merchant is ushered into the chamber, offered a comfortable chair close to the judge, greeted warmly, while the farmer has to stand way over in the corner.
The farmer knows. The farmer intuitively understands that the judgment is already decided.
It's preordained. The optics have destroyed the possibility of justice before a single word is spoken.
So justice must not only be done, it must absolutely be seen to be done. That old saying.
This mandate preemptively attacks the psychological advantage that status or wealth naturally confers in any society.
The constitutional consequences are really clear then. It denies any favoritism in appearance. The judge can't afford to smile more warmly at an acquaintance or an influential person.
Right. It mandates no intimidation by status. The courtroom must become a kind of neutral bubble where your social rank is temporarily suspended at the door.
The judge has to actively make sure that both parties feel equally seen, equally heard, and equally respected.
It levels the playing field physically and psychologically, and that is the crucial foundation for public trust.
So if the court manages to achieve that physical, visible equality, the next step has to be establishing the rules of engagement for the dispute itself.
Yes.
And this brings us to core principle 2, the foundational rule of evidence. And this contains what is maybe the most famous and universally adopted maxim from the entire letter.
It is. That maxim is, proof is upon the claimant, oath is upon the denier. This single sentence, it establishes the entire architecture of evidentiary procedure. It's the heart of any adversarial system.
And that phrase, it has been adopted and adapted by nearly every major legal system on the planet for well over 1,000 years. What are the mechanical implications of placing that burden squarely on the claimant?
It creates an immediate, immense structural safeguard for the entire populace. The claimant, the accuser, the plaintiff, they carry the burden of proof.
So they have to do the work.
They have to proactively gather and present objective, verifiable evidence to back up every element of their claim or their accusation.
And conversely, the defendant is protected.
They are protected by the foundational concept of being presumed innocent or non-liable until that objective proof is presented successfully.
That is the essential protection of liberty, isn't it? The defendant doesn't have to scramble to prove a negative that they didn't do something. The claimant has to actively prove the affirmative that they did.
And this prevents a society from being overrun by frivolous or malicious litigation.
How so?
Well, if every accusation had to be disproven by the defendant, the powerful could easily use the courts to harass and bankrupt their weaker rivals. Just keep filing claims.
Of course. By placing the burden on the accuser, Umar established a principle that protects the social and economic stability of the entire state.
It's a firewall.
You mentioned the second part of that maxim, oath is upon the denier. In what circumstances does the oath come into play, given that the emphasis is so heavily on objective proof?
The sources are really clear that the oath is strictly a secondary element. It's a supporting mechanism. It's deployed when definitive, objective, physical evidence is absent. You see this a lot in, say, financial or contractual claims, where maybe only the two parties have direct knowledge.
So it's a last resort.
It functions as a final check. It utilizes the high moral and religious weight of swearing before God to compel truth when no other evidence exists.
But, and this is the crucial point as defined by this letter, the oath is not a substitute for robust proof when physical or direct evidence is available.
Absolutely not. The system prioritizes evidence over mere affirmation. It demands objective proof first. The oath is reserved for inconclusive situations, serving as a procedural tool when evidentiary gaps exist.
But it always maintains that core principle. The defendant is shielded unless the claimant meets their high standard of proof.
Correct.
So once that objective evidence, often in the form of witnesses, is presented, the judge has to know how to weigh it. And this brings us to core principle 3, standards for evidence and testimony. It mandates that the court is concerned with quality, not just quantity.
And this is where the wisdom of the system really shines. It prevents courts from becoming hostage to, simple mob rule or factionalism.
Just getting a bunch of your friends to show up and say the same thing.
Exactly. The letter instructs judges that evidence must be judged not by a counting of heads, but by the quality, credibility, and moral character of the witness.
Wait a minute. If the judge is instructed to evaluate the moral reliability of a witness, doesn't that open the door to subjective bias? How did Umar protect against the judge just using character assessment as an excuse to reject a witness from a tribe or a group he didn't like?
That's an excellent question, and it's one the sources address with the concept of judicial discipline. Moral reliability wasn't meant to be a deep dive into the witness's private spiritual life.
So what was it then?
It was an assessment of their known public reputation for truthfulness, for honesty, for reliable dealing within the community.
So it's not about their personal piety, but their public integrity.
Precisely. The judge is given clear instructions for judicial screening, which required looking for external, verifiable factors. First, they must evaluate credibility and moral reliability. Are they known perjurers, or are they known to manipulate facts for gain?
Okay, that's one check.
Second, and this is a major check on bias, they must assess the consistency of their accounts under focused cross-examination. Inconsistencies destroy credibility, regardless of someone's moral standing.
So you can be a good person and a bad witness.
Yes. And the third instruction, rejecting biased testimony, seems designed specifically to fight that factionalism you mentioned earlier.
The idea of a vested interest.
It is a critical safeguard. Judges were explicitly required to reject biased testimony from people who stood to gain financially or personally from the verdict.
So a direct business partner, a known rival,
A family member with a vested interest, they would be screened out, or at least their testimony would be given reduced weight, even if they were generally considered truthful people.
It's a very sophisticated, multi-layered safeguard against the contamination of evidence. It ensures the verdict rests on fact, not just on the enthusiasm of interested parties.
The integrity of the evidence pool itself is protected.
Now that we've established the structure for the litigants, the letter shifts focus. Because no matter how fair the procedure is, the system ultimately relies on the person wearing the robe.
It's judge.
And that brings us to a fascinating piece of, 7th century administrative psychology in Part 2, governing the integrity of the judge himself.
This section reveals a deep, almost clinical understanding of human psychology and the fallibility of man under pressure. Core Principle 4 deals explicitly with judicial patience and mental composure.
And the instruction itself is a direct acknowledgement of human weakness.
It is. Do not decide while angry, tired, hungry, or distracted.
I find this absolutely revolutionary for its time. It constitutionalizes the necessity of a clear mind. It's like due process for the judge himself, preventing his personal state from inflicting harm on the litigants.
It is a prerequisite for justice. The source material explains that this instruction defines judicial independence as including mental independence. The integrity of the decision is entirely compromised if the mental state of the decider is compromised.
Can we break down those specific mental states mentioned and the risk that comes with each one?
Of course, anger inherently distorts justice. It pushes the judge away from objective law and toward personal retribution. The ruling becomes punitive rather than corrective.
It becomes personal.
Yes. And fatigue and hunger, they weaken judgment. They lead to missed nuances, simple legal errors, or just rushing the process because the judge is physically uncomfortable and wants to go home.
And what about distracted? That seems a bit broad.
Distraction here covers everything from personal worries to external pressure, political pressure, social pressure. All of it creates error by rushing the decision-making process or tempting the judge to just simplify a really complex case.
So by instructing the judge to postpone a ruling until they're composed,
Umar elevated the judge's self-care, in a way, into a constitutional duty that protects the rights of the litigants. The system implicitly mandates that a judge must possess sufficient control over their environment and themselves to ensure a clear mental state.
so if a judge is too tired or emotionally compromised, they are actually required to defer the ruling. They have to protect the litigants from their own bad day. That is profound self-discipline built right into the system.
It is. And it's the foundation that enables the next and arguably the most culturally and legally revolutionary instruction in the whole letter.
Which is?
Core Principle 5, Reconsideration and Error Correction. This directly challenges the ego and the finality that's so often associated with judicial power. The mandate is crystal clear. If you judge today and later realize you were wrong, return to the truth.
That instruction on self-correction is truly groundbreaking. We need to spend a little time here just discussing the cultural weight of reversing a judicial decision in 7th century society. Wasn't a ruler's or a judge's word often treated as, well, nearly infallible, culturally speaking?
It absolutely was. In many contemporary monarchical or tribal systems, reversing a final decision was perceived as a profound loss of face, a sign of weakness, even a challenge to the ruler's authority.
But this letter just flips that script entirely.
Completely. It constitutes the formal destruction of judicial arrogance.
And how does the source material justify this reversal? What's the logic?
It does so by establishing the supremacy of truth. The goal of the judiciary is not the finality of the judgment. It's not the preservation of the judge's reputation. The goal is ultimate justice.
And so this instruction, it formally establishes the fallibility of judges. They're human, they will make mistakes.
And it places the supremacy of truth over judicial pride. The legal process must be iterative. It cannot be rigid.
And this naturally leads to the legitimization of some kind of review mechanism. If a judge can change their mind, then there has to be a mechanism, whether it's internal or external, to review the fairness of the original judgment.
Yes.
This is the very basis of an appellate structure, centuries ahead of its common adoption in other systems.
Exactly. This very instruction is cited by later jurists as the basis for istinaf, which is review or appeal. Correction is formalized as strength, not weakness.
That's such a powerful idea.
It is. If the community knows the system can correct its own errors, even self-correct, it maintains trust and legitimacy far more effectively than a system that pretends to be perfect but is demonstrably flawed.
Can we find any evidence in the sources of specific mechanisms that were put in place to oversee this? How was error correction actually administered day to day in such a vast empire?
The sources indicate that judges were required to maintain detailed records of their proceedings. So if a litigant presented new evidence, or if the judge themselves found new compelling facts, the process of correction involved recalling the parties and publicly documenting the reason for the retraction or the modification.
So it's transparent.
And furthermore, the Caliph himself, Hazrat Umar, appointed inspectors who would tour the provinces to ensure judges were adhering to these procedural rules. This created an external layer of accountability to check judicial arrogance and make sure the process was consistently followed.
That adds immense practical weight. It's not just a moral aspiration, it's an administrative system for auditing the truth. A perfect system is impossible, but a correctable and auditable system is trustworthy.
Well said.
Let's transition now into part 3. The letter has established the courtroom optics, the evidence standard, and the mental fitness required. But what happens when a novel case arrives, a situation not explicitly detailed in the Quran or the Sunnah? This brings us to core principle 6. analogical reasoning, or qiyas.
Right. The expansion into complex trading hubs and societies meant that judges were constantly encountering new commercial practices, new social scenarios that lacked any explicit textual guidance.
And Umar's mandate was that the judge can't just shrug their shoulders.
No, they must use their intellect to seek a solution that is consistent with the spirit of the law.
This means the system was designed to be adaptable and rational, not rigid or reliant solely on historical precedent. How specifically were the judges instructed to use qiyas? What was the method?
They were given a very clear methodology. First, they must exhaust the explicit texts, the Quran and the Sunnah, the prophetic tradition. If a solution was absent there, they were then commanded to apply analogy, qiyas.
And that involves a specific process, right?
It involves a four-step process, which really forms the bedrock of Islamic jurisprudence.
Could you walk us through those steps?
Certainly. First, the judge must identify the novel case, which is called the far. Then they must find a parallel established case, the asl, where the law is already known.
Okay, so you find a precedent.
Exactly. Third, and this is the P intellectual step, they must determine the shared effective cause, the illah. This is the common legal reason or rationale that links the two cases. Finally, they apply the rule, the hukam, of the established case to the new novel case.
Let's try a hypothetical, maybe a slightly modernized example to illustrate how this preserves the system's ethical core. Say a judge in 637 CE is confronted with a new form of trade, perhaps a complex future delivery contract for grain, which isn't explicitly mentioned in the texts.
Okay.
How would qiyas apply, particularly when you think about the overarching objectives of Islamic law, the maqasid al-sharia?
That's where the discipline comes in. The judge wouldn't just invent a rule. They would look at an established case, the asl, say, the prohibition of uncertainty garar, in a simple barter trade.
Right.
They would then analyze the new future delivery contract, the far, and determine if the same underlying cause, the iya of uncertainty that prompted the prohibition in barter, also exists in this new contract.
So if the new trade contract undermines those fundamental objectives of justice,
The maqasid al-sharia, like the protection of property, wealth, or reason.
it would be treated analogously to the prohibited barter.
Precisely. The maqasid act as the constitutional limits on the judge's intellectual discretion. They ensure the analogy serves justice, not just personal opinion.
This mechanism, it legitimized sophisticated judicial reasoning, but within defined ethical limits. It ensured the system was capable of governing a global empire while remaining rational and morally sound.
It's a formalized structure for continuous legal evolution.
And this rational approach, it then has to be balanced by efficiency. Otherwise, all the intellectual rigor is, well, it's useless. This brings us to core principle 7, no delay in justice.
This point is critical to the functionality of the system. Umar held a profound administrative and ethical belief that justice delayed, even if it's ultimately correct, is injustice in effect.
A ruling that arrives 5 years too late allows the underlying dispute to fester. It could cripple commerce, ruin families, or even cause vigilante violence.
Absolutely.
So what were the actual administrative challenges of enforcing this in a rapidly expanding 7th century empire? I mean, judges weren't exactly using electronic docket management systems.
No, they weren't. The instruction mandates an emphasis on prompt, decisive action. Judges were required to focus on timely hearings, making sure cases were not simply shelved, and the avoidance of unnecessary delay.
So the judge had to actively manage the litigants, preventing them from using procedural tricks or evasions to draw out a case indefinitely?
He wasn't just a passive arbiter. He was an active administrator of the court's calendar.
A manager of justice.
A manager of justice. And furthermore, the instructions demanded prompt enforcement of rulings. A judgment on a property dispute is worthless if the local governor or the powerful defendant just ignores it for months.
Right.
The judge had the authority to compel swift execution of the verdict, reinforcing that the legal system must be a practical tool for societal function. Efficiency is intrinsic to justice.
So this entire document, these principles of equality, evidence, judicial temperament, correction, reasoning, and speed, it's all synthesized in the final sections, which define the relationship between the judge's freedom and the judge's accountability.
Yes. The section on the binding nature of the letter makes the ultimate assertion. Judges are independent. They are free from external political or personal coercion in their decisions. But they are definitively not unregulated. They are not free agents.
So judicial independence and judicial discipline are not opposing forces here. They're mutually reinforcing pillars.
Exactly. Procedure binds discretion. The letter specifies that the judge cannot decide on a whim. They must follow the established written steps for handling evidence, for assessing testimony, for applying reasoning.
And this procedural binding ensures that uniformity protects fairness across the entire vast state.
The system is designed to prevent a single wise or powerful man from turning his courtroom into a personal fiefdom. It's the framework that guarantees consistency and predictability. It ensures the law survives the personality of any individual judge.
Let's move now into part 4, because we have to analyze the profound constitutional impact of this letter. This wasn't just a successful administrative document, it reshaped the legal landscape for a millennium. What is the historical legacy of the Abu Musa al-Ash'ari letter?
Its legacy is just immense. It rapidly became the fundamental basis of Islamic procedural law across the entire burgeoning state. It wasn't discarded upon Umar's death, rather it became the universally accepted template for court systems.
And its authority endured through that whole foundational period of Islamic jurisprudence.
Absolutely. The letter was cited extensively by classical jurists for centuries. As the four major madhib, the schools of jurisprudence, Hanafi, Maliki, Shafi, and Hanbali, as they developed their comprehensive legal theories, this letter formed the administrative bedrock for their procedural codes.
It was the practical link.
It was the crucial practical link between the ethical imperatives of the Quran and Sunnah and the daily functions of the court. Scholars even developed an entire body of literature known as al-Qadi, the literature on the conduct of the judge, based on the procedural and ethical mandates laid out in this one letter.
This stands as powerful evidence of early Islamic legal sophistication. I mean, when we look at the historical timeline, this document codifying due process, the equality mandate, burden of proof, the right to reconsideration, it's operating centuries before similar robust written procedural doctrines emerge in many parts of the Western world.
That is the striking historical comparison. The principles of formalized equality and strict burden of proof laid out here in the 7th century precede the development of key procedural protections in, say, English common law, which evolved much later alongside concepts like habeas corpus and specific rules of evidence.
So it shows an early state-level commitment to the rule of law.
A deep commitment. It formalized what had previously been an aspiration into binding constitutional procedure.
Which brings us right to the contemporary relevance. These aren't just historical footnotes. These 7th century principles are structurally identical to the pillars of modern courts today. It just demonstrates their timelessness.
If you examine any modern judicial system, you will find these rules. The requirement for formalized equality before law, no visible favoritism, no advantage for status, that is a cornerstone of constitutional rights globally.
And we still maintain strict requirements for the burden of proof.
We do. The prosecution, or the claimant, must prove their case beyond a reasonable doubt. It protects the citizenry today, just as Umar intended for it then.
And the commitment to due process, the right to be heard fully, to have a verdict based on consistent reasoning, and to have a judge who is mentally fit to decide, we take that for granted today as a universal human right, and yet here are the administrative origins.
Furthermore, we rely so heavily on sophisticated systems for appeal and review. Error correction. That principle, that truth must trump judicial pride, is the entire basis for appellate courts and Supreme Courts, which are designed to oversee and correct the fallibility of lower judges.
The system for self-correction evolved into a layered system of oversight.
It did.
And even the principles of judicial conduct, the expectations regarding judicial temperament, patience, impartiality, lack of bias, those are core tenets of every judicial code of conduct today. It's remarkable how little the fundamental requirements for a functioning court have really changed.
The letter proves that Islamic law, even in its earliest administrative form under Hazrat Umar, was fundamentally procedural, rational, and humane.
It was designed not just for moral instruction.
No, it was for the practical, predictable, and fair administration of a vast, complex society under the rule of codified law. It's the difference between relying on hope and relying on a structure.
As we conclude this deep dive, let's just reflect on the profound political and constitutional wisdom that's embedded in this one administrative letter.
Hazrat Umar's genius, I think, was rooted in an understanding of governance that transcends any individual lifespan. He knew that rulers and strong personalities, they pass, but written procedures endure.
By institutionalizing justice, he was building a system designed to outlive him, to outlive the current generation of wise judges.
By making procedure the binding force, the letter ensured that justice would survive periods of political pressure, periods governed by weak or less wise judges, and even attempts by powerful governors to interfere in local rulings.
The law became independent of the individuals who executed it.
This focus on procedure is the structural foundation that guarantees consistency and predictability, regardless of who happens to occupy the seat of power.
So, the provocative concluding thought for you, the listener, is this. When power fades, procedure protects truth. This letter, written nearly 14 centuries ago, is not merely a historical artifact. It's described by scholars like Mr. Mir as living constitutional law, a blueprint for judicial integrity that remains just as relevant today.
A truly enduring legacy of governance.
Next time, we'll continue our exploration of Hazrat Umar's constitutional decisions by looking at Case 11 in Mr. Mar's work, merit-based appointment of judges who is fit to judge others. We will unpack the demanding criteria for judicial appointment that ensured the integrity of the judges themselves, which complements the integrity of the procedure we discussed today. Thank you for joining us for this deep dive.